Mr. Chief Justice, may it please the court. This case turns on the language of Iowa Code Section 903.2. That code section states that sex offenders are not eligible for sentence reduction credit or earn time unless they complete sex offender treatment. The inmate in this case, Marshall Miller, is a convicted sex offender and was required to complete sex offender treatment. He was given an opportunity to participate in SOTP, and he failed to do so. In 2015, an ALJ decision upheld his removal from SOTP. In 2016, the Iowa Department of Corrections revised its policy with respect to earn time for sex offenders.
Why?
In order to correct a long-standing misapplication of a law that was enacted in 2005. Basically, Mr. Miller and other inmates who had failed to complete SOTP had been given credit for earned time to which they were not eligible. Now, this policy change had the effect of moving Miller's discharge date from prison out by 3 years. It did not extend his sentence per se, but it did push out his discharge date.
How many other inmates are affected similarly?
Approximately 150, I believe. I don't remember. That number fluctuates a little bit because some inmates have come in and completed treatment since then. And so, but I think at the time the policy was changed, it affected about 150.
One thing that's been bothering me about this is that we've had 4 or 5, maybe more, maybe less, cases dealing with this regulation about losing earned time. And I'm wondering, can you point to any of our cases where we agreed with either the old interpretation or somehow stated that the old interpretation was wrong?
Sure, and to answer that, I think there are 5 cases that are important to look at here. The first is Holm, which was a similar ex post facto challenge to this exact same statutory language that was brought in 2009. And Mr. Holm was a person who had been convicted in 2002. The ex post facto challenge was essentially that applying this policy to Mr. Holm wasn't right because he had been convicted 3 years prior to the statute being enacted. Now that's very different from the current circumstance when Mr. Miller has been convicted 6 years after this statute.
Maybe I should ask it another way. I'm concerned that if we approve the interpretation and said that is the way the law should be interpreted, either explicitly, implicitly, or explicitly in any of our prior cases, does that create ex post facto problems? And the second part of that question would be, had we affirmed that interpretation either explicitly or implicitly in any of our cases?
So I think this case turns on the word required. What does the word required mean? The statute reads, an inmate required to participate in sex offender treatment shall not be eligible for a reduction of sentence unless the inmate completes SOTP. That's the statute that was adopted in 2005. In the Holm case, at the time of Holm, IDOC interpreted the word required to mean at the moment a person is offered a bed in sex offender treatment. Subsequent to that, there was the Dykstra case, the Riley case, and the Waters case, which taken together illustrate that required happens at the moment of criminal conviction. And in fact, this court said in the Harkins case, the Webster County case in 2011, from the moment Mr. Harkins committed his crime, it was clear that if he was convicted and chose not to participate in treatment, he would not be eligible for earned time credits. So that's 2011. And so I would suggest to you that the court's definition of the word required changed, which means that the policy underlying SOTP.
Why did it take another 4 or 5 years before the department changed its policy?
That's an excellent question, and the best answer I have for you is this. There was a change in administration in the department. There was changes in staffing, and then there was a subsequent cases that required both the attorneys and the staff to look at the policy. And in the regular review of IDOC policies, this misapplication was brought to the attention of the folks involved, and a decision was made that it needed to be corrected.
Does the record show what the department's capacity is for treatment? In other words, to what extent is treatment available for from day one?
Sure.
Okay, go ahead.
And that is not available as part of this record. But what I think is in this record are the arguments that were made at the district court, which talk about that very issue. And the department has adopted this idea that treatment is most effective, and that's the goal here, is having effective treatment, is most effective when it immediately precedes somebody's reentry into the community. So the policy as it's now constituted is, we're going to put you into treatment at a time where it will, the earn time coming down and your days in prison going up will meet at a point where you will complete treatment and then be ready to be released in the community. That's the moment of maximum treatment benefit, when it's fresh in the inmate's mind. Because of that, because the decision is made that treatment is more effective later in an inmate's sentence, the decision was made that the policy should allow inmates to not be punished for that they should be able to earn time as if they got SOTP the minute they walked in. And at the same time, for inmates that fail to complete, it's a fairly significant sanction. The goal of the statute is that untreated sex offenders don't get out of prison early. And so you either participate in the treatment or you serve the whole sentence.
Anything in the legislative history that would support the department from changing its interpretation?
I'm sorry, could you support the
Is there anything in the legislative history of the statute that would support the department from changing its interpretation of the statute midstream? We know why they did it, but why they did it has to be consistent with the legislative history or intent.
And the legislative history of this particular section is not available. But what I think is so striking about this particular code section is that it begins with the word however. I went through as much of the Iowa code as I could. I can't find that word in very many places.
But we decided, as you said, 4 or 5 cases, putting out to the world, including the legislature, that it's being interpreted that way. And I saw no legislative action basically saying, well, that's not really what we meant. We better go in there and make it clear that it's the other way.
And I think the distinction between the 2005 statute and the 2001 statute as it was done in Holm is that in 2005, the legislature said, no, we really, when it comes to sex offenders, we want sex offenders to take SOTP. And that's the significant change between 2001 and 2005 is it's the clarification of this particular piece. Now, as to why no action was taken prior to 2016, what I would suggest to you is that this was to the inmates' benefit. Inmates were getting credit for earned
The
time.
legislature didn't make any changes, saying, one can assume that you were interpreting right up to that point. If you weren't, the legislature can always go in and change it. And when they think we did something wrong, they're not shy about going in and changing the statute.
And I would suggest that I don't think this court did anything wrong. I don't think this court needs to overrule Holm or any of its prior cases.
I'm not saying that, but the legislature was had to be aware of the way you were interpreting it, and yet didn't change the statute. That's the point I'm trying to make. And what does that tell you, or what should that tell us?
Well, it suggests to me that the legislature thought the language of the statute was plain. When they set off a section with the word however, we have this section which talks about earned time and how people can accrue it. But however, sex offenders don't get earned time until they do treatment. I'm not sure what the legislature could have done to make this any clearer.
And Mr. McCormally, if we didn't have Holm, if we didn't have these other decisions, if we were just looking at the statute and also looking at what is sound policy, I think you'd have a real strong case. But my concern is it's almost like judicial estoppel. you came in home in 2009 and you said the 2005 amendment didn't change what was the law in 2001, and you won. We ruled for you, and Mr. Mears lost. And now you're saying you're necessarily that 2005 had to have changed the 2001 law, because the 2001 simply said that you get, when you complete it, you get earned, or as you're participating, you get earned time credit. It doesn't talk about forfeiting or not being eligible or any of those things that are in the later iterations. So that's what I find troubling. So help me on that.
Sure, and I think that the answer to that is that this court adopted the interpretation the department advanced as applied to Mr. Holm. And that was, the department's policy was Mr. Holm was going to be credited with earned time up until the point he refused, and after that he wasn't going to get any. Had the department advanced this interpretation in Holm, I'm not sure the result would have been different, because the critical change in Holm, and I think to understand Holm fully, you need to look at that Prop case that came out a few months before. Prop was convicted in 1997, and this statute was ex post facto applied to him. And the reason for that is because the change in legislation was to separate good behavior, to combine good behavior and treatment participation. Prior to 2000, when Mr. Prop came to prison, you could earn a credit for treatment participation and a credit for good behavior. After the legislature changed it in 2001, you had to do both. You had to do both good behavior and participate in treatment in order to get the 1.2 days. Fast forward to 2005, what the legislature really does is say, by the way, when it comes to sex offenders, we really mean they have to do treatment before they get anything. That's not really different from what the law said in 2001. The law in 2001 says you have to participate in order to get sentence reduction credit.
Is this your position supported by 903A.3 that expressly provides for the forfeiture of already accrued earned time if an inmate violates an institutional rule? Is sex offender treatment, is that an institutional rule?
It is, although I would suggest that forfeiting earned time only happens when somebody has actually accrued it. And if you're not eligible to accrue it in the first place, I'm not sure we even get there, but certainly as a sanction, it would be an appropriate sanction to take away all the earned time somebody has accrued under that policy.
Maybe I should have asked this question first. Do the inmates have a credible reliance argument that up through the end of 2015, we thought we accrue earned time, we're not going to lose that if we later refuse or flunk out a sex offender treatment program?
This court in Holm said the ex post facto clause does not prevent the misapplication, protect against the misapplication of a law. Essentially saying, you might know DOC is getting it wrong, but if you're relying on DOC to continue getting it wrong, that doesn't save you, right? The fact that Mr. Miller thought he could make a choice between doing treatment and not doing treatment and then get earned time to which he was not eligible, that doesn't protect him. The law, when he came to prison, stated this very clearly. You're not eligible until you participate. And so certainly as applied to Mr. Miller, I don't believe there's any kind of ex post facto issue.
I don't know. I don't know if I agree with that, only because we do have a period of time here of the 3 years, if I'm reading the record correctly. You know, he was institutionalized in 2012, and then in 2015 is his first opportunity to participate in the programming. And so we do have a period of 3 years, which I assume, and I haven't looked through the record in great detail, but I assume he was an okay prisoner through that time. He would have otherwise been able to get earned time credit for that 3 years. And now, with the change in the interpretation, whatever you want to call it, with the change in the rules applied to him now, he's going to lose all 3 years when he was, in fact, doing exactly what earned time is meant to do, which is to follow the rules while you're incarcerated. And so that's a bothersome thing to me. You know, once you offer him the programming and he obviously fails, then at that point forward, then I don't think he certainly should get credit for that, but what about that 3 years?
My time has almost expired. May I respond? Thank you. When Mr. Miller entered prison, he was identified as somebody who's going to have to take SOTP. And based on the plain language of the statute on the books, I would argue that he's on notice. This is a possibility. But he was hardly a model prisoner. He had 2 separate opportunities to begin and complete SOTP and had discipline issues. He had a major forgery issue that caused him to be transferred out of Mount Pleasant entirely. And so if there was an incentive, it wasn't doing a whole lot for him. But again, I would go back to the fact that this is the state of the law at the time he came to prison. And the fact that the department was misapplying the law does not entitle to earn time under which the statute clearly says he's not eligible. Thank you.
Thank you as well, Counsel. Mr. Mears.
Good morning. This is a rare opportunity for me that I was here in 2008 or 9 arguing the home case and I lost. And now I'm here before you kind of saying, I lost, okay, but now you shouldn't be able to say, I should have won, which is sort of what the AG's office is saying. A couple of things. First of all, with regard to Mr. Miller, that his sentence in January of 2016 was extended by almost 4 years. That was 4 years of earned time that he had earned up until that point. He had some discipline. There are time computation sheets galore in the appendix from below, and that he had some disciplines, but that for the most part, he had, as I say, earned almost 4 years of earned time for following the rules. That since 2005 and 2006, for the most part, inmates don't just go to their counselor and say, by golly, I'm not going to have anything to do with treatment. That they know that there is a not insignificant consequence to that and has been since 2005. And that rather what happens is a refusal today is sometimes like Miller, where you may get some kind of disciplinary problem, even though the other problem in Miller, of course, was that he had been assaulted the day he got to Mount Pleasant. There was an enemy situation, and the DOC couldn't keep him safe, and that was the only place that they had to offer him SOTP.
Let me ask this question. If we were starting from scratch, Holmes and all, Props, all those, Dykstra, all those cases didn't exist, is a reasonable interpretation of this law that if you don't take SOTP, that you lose all your earned credit, whether it's before or after your refusal?
That I believe that could have been a reasonable interpretation. I argued that in the home case.
And however sort of somewhat leads to that conclusion, doesn't it, the word however?
Well, you still have to wrestle with the question of required. And
I did look at the legislative, wasn't much, but there was a fiscal note attached, and it assumed that it would cost more because these people would get no earned time if they didn't take SOTP treatment. Now, I don't know what that means.
Well,
But that's how the Legislative Research Bureau interpreted the law, I think, when they presented their fiscal note to the legislature.
well, that whole bill in 2005 was sort of put together rather quickly after that little girl was killed in our part of the state, and that that part of the statute was added, I think, because of the perpetrator over there having been in prison and not having.
It did go through legislative research to get a fiscal note. I mean, it wasn't.
Sure.
It's not like the repeal of the Affordable Care Act where they're trying to avoid a fiscal note.
Is the statute ambiguous? Is required in this context something that can be reasonably read 2 ways?
You know, what Judge Anderson said in his ruling was that while there may have been ambiguities or questions about what the 2005 amendment meant prior to home, they were settled by the decision in Home. In subsequent cases, the Iowa Supreme Court has not changed its interpretation. In answer to one of the questions about what about these other cases, and I think, and I put them all down, quite frankly. I was involved in a good portion of them, and in virtually every one of them, the language used by the courts in talking about what happens when a person doesn't take treatment is that the accrual of earned time stops. There was clear recognition after Home that that was in fact what the DOC was doing.
Would the inmate, in this case, have changed his behavior if he could have foreseen that in 2016 the department would change its policy? Is there any detrimental reliance on the continuation of the Home interpretation?
I think what I pointed out in my brief was that the main reliance that Mr. Miller could have had was the knowledge that his release date was changed to being only about 5 or 6 months away, and that wouldn't have been time enough to do a post-conviction. There are other people, I might add, who refuse, who during this time might refuse if they had a pending post-conviction, for example. And that one of the cases that's in the group following this was a person who had a pending post-conviction and that made a calculated judgment based on the pending post-conviction that he'd rather take that extra 10 months than jeopardize his post-conviction by having to admit his crime. So that the level of reliance does change from case to case. But in this case, Mr. Miller would have, I believe, taken a post-conviction, at least after he got the ALJ decision. You know, he's not going to have changed the fact that he got assaulted, that he probably wasn't going to change the fact that he misbehaved, but had he been sanctioned at the time in October of 2015 for losing 4 years of time, I guess the other place that I think about Pettit, because Pettit's another tiny piece of the puzzle, the question of whether or not you get counsel or should hire counsel to go to one of those ALJ hearings. If you know that there is, 2, 4, 8 years of time riding on this, you probably are going to try to find a lawyer to assist you, at least in presenting the argument.
What about the statute 903A.3 that allows for the forfeiture of accrued earned time for violating a rule? Would inmates have known from that or their counsel that even if your refusal or you flunk out of a sex offender treatment program some years into your sentence, that one consequence might be loss of already accrued earned time?
For about 20 years, the department has had a sort of schedule of rule violations in terms of there are Class A violations, B and C, which have caps of how much time can be taken. I think that if you refusing treatment isn't in one of those high caps that could cost you 2, 4, 10 years of time. I mean, those are, you have to seriously hurt a guard, presumably, to lose that level of time.
Doctrine of legislative acquiescence come into play here after Home was decided, and we said in that case that it means you don't lose earned time already accrued, it's just you stop accruing it. The legislature didn't step in and overrule or change that. What weight should we give that non-occurrence?
That I do think that there is a doctrine that allows you to construe ambiguous statutes in the way consistent with how the agency has been interpreting it up until that point. I mentioned that in my brief. The other thing, though, was that there was, and this, Mr. McCormally in his brief uses the term foreseeable, that Miller can be, this isn't harsh on Miller because it could have been foreseeable. And he takes this language from something this court said in the Home case, that because, and this goes to the question of whether the change administratively can be of ex post facto violation, that what this court said was because the 2005 amendment did not result in more onerous punishment, and because the loss of future earned time was foreseeable, the application is not a violation of ex post facto. I assert that, that once the 10-year period of DOC policy is added to a Supreme Court decision adopting that interpretation, it certainly would not have been foreseeable for Miller to think that he might lose 4 years of time. And that would make it, that the two things that Judge Anderson did in this case was, first of all, he said, this is inconsistent with the statute as construed by Holm. That the statute says required, and that you get the time up to the point in time when you refuse. That was the interpretation. But what he said as a second matter is, if I'm wrong, what happened here was a dramatic change in administrative policy of how this was, and that unless that's foreseeable, that's an ex post facto violation. And you can have an ex post facto violation with an administrative change in the way something is interpreted. That I guess that I come back to Holm, and as if we were writing on a blank slate, I would say that a reasonable interpretation might in fact say that sex offenders were a different, you have your 85, you have your people that get 85% earned time, and you have your people that get 45% earned time, or 55% earned time. And then you have sex offenders, and they are a different category. And but that's not what was said in Holm. That is, that argument was rejected in Holm, and Holm was, the Holm had to stay in prison another 3 or 4 years.
Aren't we governed, though, by the plain text of the statute, which in your home brief, you noted the statute doesn't say sex offenders get to accrue earned time for maybe 2, 3, 5, or 7 years until a bed is available. Statute says individuals, quote, required to do treatment, close quote, don't accrue it at all until they complete the treatment.
And that's why the term required became so important in my view in terms of how the court, what the DOC did in making their argument in Holm was saying that the key word there is required, and that we're not requiring it until a bed is available. And I might add,
so is required ambiguous?
well, not after you interpreted it. And that was the position again of the DOC. That and I might add, somebody asked about, what their resources are and so forth in terms of, I was trying to see whether there was something in the record. I'm not sure we have anything in the record but that the reality is that sex offender treatment is primarily offered near the conclusion of a person's sentence. And I might add, speaking of sentences, the sentences that you have today all carry special sentences, as opposed to Holm, when a person got out and perhaps if he hadn't had any treatment at that point, you would have an untreated sex offender on the street with no supervision. All these guys, Miller will have, and I might add that he only has a non-forcible sex case, that treatment should not be that difficult, but that he's going to be on lifetime special sentence if this court affirms the district court decision below and releases him. He'll go probably to a halfway house where he will immediately do treatment, and he will be on supervision with the special life sentence for his life. That's different than Holm. If in a way, there's less reason to do this today with those special sentences. My time is almost up, but that it's at, footnotes can be so important, of course. Footnote 2 in the Holm decision that talked about the differences between the 2001 and 2005 amendment. And what this court said was that the 2005 amendment made it clear that an inmate for whom treatment was identified did not lose his eligibility for earned time credit until the inmate was actually required to participate. And given the reality of having sex offender treatment near the end of your sentence, that's years of time. And the Attorney General's office got you to accept under plain text that required was the important word.
Well, what's wrong with the proposition, though, that, you know, while you're in prison and while we're awaiting a bed, so here, if my recollection of the record is correct, then you're gonna have about 3 years, and during the period of time that we're waiting for a bed, you know, you are eligible for it, we're gonna show it as being accrued. However, if in fact you don't successfully complete it, you're just gonna lose it. I mean, isn't that a correct interpretation of what the statute says? I mean, you can go into that
And
knowing that, well, sure, you know, we're gonna keep showing that for record-keeping purposes, and you are eligible for it, at least at this point, but once you get to that threshold point where you aren't successful or can't complete it or don't complete it, you're gonna lose it. What's wrong with that interpretation of the
well, and
statute?
if we were writing on a blank slate, I think that, I've already said, I thought that might be a reasonable interpretation. I probably said as much 8 years ago in terms of trying to argue that Mr. Holmes should be released. And even though the other thing is that doing it that way means that the consequence of failing a polygraph or getting in a fight so you get expelled from treatment or something like that winds up being far disproportionate to what probably the misbehavior was. And that, keeping in mind, if you're in treatment and you get in a fight and you get kicked out of treatment, you're going to get disciplined for the fight in accordance with the rules, their standard of punishment. But that if you also, on top of that, get kicked out of treatment and lose 6 years of earned time, and I might add, when you get back in treatment and complete the treatment, you don't get that time back. Anyway, as I say, it's not very many times that you have a chance to revisit a case that you lost and use the decision where you lost in support of what you're arguing. But I have now done that, and for the reasons expressed by this court in the home case, as then reaffirmed by 6 years of inactivity. The AG's office didn't go to the legislature and try to get anything changed. The DOC didn't. Ask you to affirm Judge Anderson's ruling and allow Mr. Miller and probably a number of other people to be released from prison to go do treatment on their special sentences.
Thank you, Mr. Mears. Mr. McCormally.
Mr. Chief Justice, I just want to begin by touching on something Mr. Mears just said. It's not the consequence of a treatment failure or a fight in prison that causes the sanction. It's the crime for which Mr. Miller was convicted. Sex offenders pose a special problem to the community. This court has said that repeatedly. The sanction for sex offenders who don't complete treatment is that they are not eligible for earned time. Mr. Mears is right. This case really does come down to the word required. In 2009, in the time of home, required meant what DOC thought required meant when DOC says time to go to treatment. But what case law since then illustrates is that required happens at the moment of conviction. In Dykstra, this court says if somebody is convicted of a sex offense, all DOC needs to do is notify him that at some point they're going to be in treatment, and that's enough for due process. It said the same thing in Waters and in Riley, and then most recently in the Jones County case last fall, which talked about an inmate who had not been convicted of a sex offense. Could that inmate be required to take SOTP? And what this court said then is that as long as that inmate was given due process, he could be required to take SOTP. But, and this I think is the critical piece of the Jones County decision, but for the inmate who had been convicted of a sex offense, due process was satisfied at the time of conviction. That moment of conviction is the moment when the requirement happens. And that is what is different between now and the time of home.
What happens, I know would be a different case, but maybe included among the 150 or so others. It's somebody who's convicted, the conviction is not on a separately defined sex offense, but it's an assault, and then after the administrative law judge hearing, it's determined it was a sex offense, treatment is required, they flunk out. Do they lose all their earned time, or only from the date of the hearing that said you're required?
And I think that what the answer in that question is, and I think it goes back to at what point was there a judicial determination of the requirement? And in that case, it would be at the moment the ALJ said, yes, this is a person required to take sex offender treatment. They've been given due process in that Wolf hearing in the prison. If they've been affirmed that they're classified as required, that's the moment of their eligibility. So if they come in and serve, a month before that requirement hearing happens, they'd get a month of credit. But after that, unless they completed treatment when it was offered, they would not get any further treatment. The other thing I want to touch on is what Mr. Mears said about special sentences. I don't believe that that has any implication on this whatsoever, because the goal of this statute and the registry and the special sentences are all the same, right? This is the legislature saying, we want to protect the public from a particularly egregious and horrible kind of offense. The special sentence is great because it allows us to take somebody who offends in the community back to prison with a pretty quick mechanism. But it doesn't protect somebody who might be victimized in the meantime. And that's what treatment is supposed to do. Treatment is the goal of treatment is to reduce sexual recidivism. And if you look at the recidivism statistics for sex offenders, the number one predictor of whether or not somebody will recidivate is, have they successfully completed treatment? Have they actually even participated in treatment is a pretty good indicator. But treatment is so critical. And that's why this section and the plain language is as severe as it is. I understand what Mr. Mears is saying, and I think the feeling of everybody here is that there's just something that seems inequitable about this situation. But the fact of the matter is, at the time Marshall Miller was convicted, the statute said do treatment or you don't get earned time. And that's not ex post facto. That was the law 6 years before he was convicted. The relevant case law all came down before he was convicted. And we talked about the other cases that are coming up. There's another case coming up before this court on this same issue that involves an inmate that began treatment after the policy change. Policy change happened in January. He began treatment in July. I would suggest to you that with respect to that inmate, there is clearly no problem because he was on notice. But for Marshall Miller, he was on notice because the law said he wasn't eligible. And I'd ask this court to reverse the district court.
Mr. McCormally, thank you. The case of State versus Jones County is now then submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.